Good evening and welcome to Chesapeake Public Schools Family Empowerment Webinar. My name is Lisa Carey and I am one of the Family and Community Engagement Specialists. Our office, which is part of the Department of Engagement, aims to build meaningful partnerships in order to inspire, engage, and empower families, educators, and the community organizations to support the initiatives of Chesapeake Public Schools. You can reach us at our main phone line or via email at the contact information listed on the screen. Thank you for joining us, and we look forward to working together to strengthen our community and support our students. Our goal is to continue to provide families with valuable webinars, events, and information to empower them in the educational setting. We are excited to offer our families the Peak Parent University course catalog. This catalog provides an overview of all the events of the school year. Here you can also catch up on pre-recorded webinars, explore a wide range of educational resources, and make valuable community connections to enhance your family's well-being. Please take a moment to scan the QR code on the screen, which will give you access to our Peak Parent University. This will provide you with the monthly updates, including descriptions, times, and locations of upcoming events. We hope you will join us for our next few events, which are listed on the screen. You can also go to cpschools.com and in the search menu, type in Peak Parent University. Thank you for joining us this evening for Future Financial Planning for Students with Disabilities. We are excited to welcome our panelist, Shannon from East Coast Elder Law. Before we get started, please note that this webinar is being recorded and will be shared on the Chesapeake Public Schools YouTube channel. For privacy and security, participant cameras and the chat feature have been disabled. If you have any questions during the session, please use the Q&A feature located at the bottom of the screen. We will address all of your questions by the end or throughout tonight's presentation. At this time, I would like to turn the program over to Dr. Frankie Dampier.
Good evening. I have the pleasure of introducing to you Ms. Shannon Lehman-Pecoraro, who is the founder of East Coast Elder Law and is a preeminent voice in elder law and special needs planning. She is one of less than 1,000 attorneys nationwide to hold the prestigious Certified Elder Law Attorney designation from the National Elder Law Foundation. It represents the highest standard of excellence in her field. In addition to guardianship and conservatorship, Shannon expertly helps clients develop estate plans, evaluate resources for long-term care, and develop strategic plans to protect their assets while ensuring access to necessary services. Beyond the office, she remains engaged in community service, continuing her lifelong commitment to making a difference in the lives of others, as evidenced by her volunteering to serve as a member of the Chesapeake Public Schools Special Education Advisory Committee. And we are very thankful for her willingness to facilitate this workshop for us. And now I'm turning it over to Shannon.
Hi, everybody. All right, let me get my screen shared. All right, so what we're going to just talk about is some basic special needs planning. And I know some of the people on here today have probably heard me speak multiple times, and every time there's a little nugget to learn. Unfortunately, when we first get some of this information, it's kind of like drinking from a fire hose at times. And so, it's hearing the same thing multiple times or in different ways sometimes help. Go ahead and ask questions throughout the presentation, because if it's something that's on your mind, it could be on somebody else's mind. And also it would be relevant to whatever I'm talking about at that point in time. So it just makes sense to go ahead and address it at that point. Okay. There we go. All right. So whenever we have a loved one with a disability, and just so you know, I am a Chesapeake mom. I do have a child with a 504. So I walk the walk in certain areas as well. But, these are the primary things that I see with families is, just planning for the disability itself. What are the long-term housing options? I will tell you that this is probably the most difficult out of all of the discussions that I do have with my families, because it's always about when is the appropriate time to transition your loved one. And This program in particular does a really good job about talking about what does that transition, especially from school, to, whether or not we're going to look at some sort of work program or whether or not we're just at home now with some caregivers. But talking about that transition and housing becomes an important piece of that. And what I would say is that we need to talk about that before something happens to you. Otherwise, I get to experience the crisis associated with that. How do we pay for long-term care needs, especially when we have a child that will not be able to take care of themselves? What assistance is available? We need to make sure that we're looking at both tax and estate planning at both the parental level and at the child level. And then also, what fiduciary duties and obligations do you have or would a successor have with regards to your child? How do we maintain public benefits eligibility? And then also, I say one of the most critical pieces of all of this is caregiver support. And that's paramount because we can love somebody, to the moon and back, but there are times that we all get drained as parents, and it's okay to acknowledge that and seek out the support that we need to make sure that, we can remain healthy for our loved ones. All right, so big picture, when we're talking about public benefits, these are what we're talking about. Okay, and so there's a side on the left where we have something that's based on financial need, and then to the right, it's not based on financial need. So what we're usually talking about is SSI in terms of the initial income that your child will have. This is an income and asset tested program, and at age 18, your child would no longer be considered a dependent of yours. And so as a result, your income, your assets do not play a role anymore in their ability to receive this benefit. We're going to get into it more, but basically they have to be determined to be disabled as defined by the Social Security Administration. And this is really the gateway then to other valuable benefits, as we'll experience later. Yes, we've got Medicaid, traditional health insurance. There are some veterans pension benefits for some of my older adults. We do look at food stamps and, legal aid and utility assistance. But what I will tell you in this list is probably the most valuable for most of my families are those waiver services. The waiver services are what is actually going to pay for in-home care or group home sittings or, whatever it might be that your loved one needs. Those services are contained within the waiver. And essentially what the public benefits programs have said is that you're quote unquote waiving your right to institutionalized care. Now, I know the vast majority of us, we don't want institutionalized. So they make it sound like it's a bad thing, but the waivers, that's all it is. It's basically saying we're receiving some sort of care outside of an institutionalized setting. Different states have other additional benefits. And then you'll see on the not based on financial needs setting, this is where we get into just regular Social Security that we would all be entitled to because we have, retired or we've become disabled. And importantly in there too is also our special education services. All right, so what is supplemental security income? And I do have a lot of clients who originally say, look, I don't really care about the almost $1,000 a month. Right. This is really just, there's going to be too much paperwork or whatever, but there are some latch-in benefits that we're going to talk about. And so SSI does become a very important part of the plan. So at age 18 is when we can make an application if we've been denied because of family income or assets. And in order to meet the test, then what they were looking at is from the individual level at that point in time, they must meet the Social Security definition of disability first and foremost. I often tell my families that as somebody who has lived, eat, and breathed inside the special needs community since I was in high school, there is a difference between a diagnosis and a disability. Under the terms of the Social Security Administration, the technical definition is that you're no longer or unable to maintain substantial gainful employment. And that has to be the result of either a physical or mental impairment that's expected to last at least 12 months or could possibly result in death. For my minors, whenever I do have, lower income and asset families, it's basically, can you perform the activities that a, typical child would perform? So they're looking at kind of, social norms. Substantial gainful activity, though, they're basically saying, can you make a certain dollar amount per year? Or per month? It's a very low threshold. I don't know the number off the top of my head, but I think it's somewhere around $1,200, could be $1,300 a month now. You and I both know that that's probably not going to sustain an individual very far, but that's a number that the Social Security Administration has put in. If you ever want to know what it is in a given year, all you have to do is keyword search that substantial gainful activity amount, and it will pop up for you. It's important to understand that then at the individual level, there is this income test that we're going to talk about, but then there's also this asset test. Once again, very low barrier. You cannot have more than $2,000 in your name, and that's going to be a combination of all of your assets. There are some exempt resources. So for instance, a house is exempt. You can own a house in your name and receive SSI, and Social Security can't do anything about it. You can't own two parcels of property, though. The second property would be a countable asset, the value of which it would exceed that $2,000 amount. The important thing to understand is that historically, SSI was for the sole purpose of food and shelter. It was a year or two ago, the Social Security Administration has actually laxed this and now said that the $994 a month, which is your max SSI amount, is for the sole purpose of shelter. This allowed for the ability to, for food stamps to supplement and all kinds of other stuff a little bit easier without detrimentally impacting your SSI benefits. And as I mentioned before, a parent's income is going to be deemed to the child up until the age of 18. All right, so this is the income test. So basically, in order to be disabled, you have to not be able to, earn, I put the numbers on here. $1,550 a month if you're not blind. And if you're blind, you can earn up to $2,590. So a diagnosis alone is not going to substantiate whether or not we can make that amount, right? I can have a diagnosis, but if I'm earning $3,000 a month, the Social Security Administration will say, well, you're able to earn over the $1,550 per month. And as a result, you are not disabled pursuant to our definition. In addition to just kind of that basic understanding of, hey, here's the hard and fast limit. If you earn more than this, you're not disabled. There's other tests that kind of come into here. So the first kind of most important rule for most of my families is what's called the in-kind support and maintenance reduction. What happens is that because the Social Security Administration has said that this benefit is for the sole purpose of shelter, if your child can receive either reduced or free shelter, they essentially have what's called the presumed maximum value rule. And what they will say is, okay, well, we're going to reduce your benefit by 1/3. In some circumstances, it might be 1/3 plus $20, but this is a big, reason whenever people come to my office and I'll say, okay, so is your child receiving the full $994? No, they are not. And I'm like, oh, well, you must not be charging rent. And they're like, oh yeah, we're not. There is a back end way, and it's kind of hard for me to talk about whenever I'm in a presentation because I usually draw it out for my clients. But basically, there is a way where we can charge rent, but not necessarily we can then save the money for the benefit of the individual. I use that in a multitude of different ways. But one of the big things that it's for is to make sure that they're getting their full SSI check as opposed to that reduced amount. The other thing that we have is an unearned income reduction. So if you give your child $100 in a month, that is an unearned income to them. They do not classify gifts as a gift. What they do is they basically say, oh, you received money. It is income in the month of receipt, and then it would be an asset for every month thereafter. So if you have unearned income, there is a $20 disregard. They will say, okay, we're going to ignore the first $20. But after that, it will be a dollar for dollar reduction. What does that mean? That means that if you've gifted that $100, they will ignore the $20, but then they're going to reduce down those SSI payments by $80 for that month. It is important to know that you have 10 days from the time something happens to actually report that that income was provided. And trust me, Social Security Administration does have their ways of finding stuff out. They may be dysfunctional at times, but finding money sometimes is their specialty, I think. And then you have the earned income reduction. So for the earned income, they want to incentivize people to get out and work. And so what they have done is they say, okay, we're going to ignore the first $65 of earned income. And then for every dollar you earn, we're only going to reduce your benefit down by 50 cents. So this allows for our children to engage in activity and, have a meaningful, productive a productive like work life, whatever that looks like for them. I like to call it redefining independence and what does it mean for them. But basically, as opposed to maybe just volunteering somewhere, they could earn some money. With the increased minimum wage laws and everything else that are coming to play, we have to just monitor the number of hours they're working without, jeopardizing their SSI. I do have plenty of families, though, who say, hey, let's go ahead and try and maximize, let them pay into their own Social Security, benefits, and maybe that would be beneficial long-term as well. So, each family is a little bit different in the way that we work this, but it is kind of important to understand that you can still work and collect your SSI benefits. Okay. So what's a resource? This is both for the Medicaid rules and the SSI rules, but basically anything that can be converted to cash is a resource. If you are over $2,000 on the first calendar day of the month, then you're going to lose your benefits. They don't care that you were down afterwards. Remember, if your SSI check is hitting in that month, it is income in the month of receipt, not an asset or a resource. And so as a result, that income coming in, they will subtract that from the first day of the month. There are some exemptions. So as I said, your principal residence is an exemption. Tangible personal property, they don't care what you have in the house. I've worked on Medicaid spend downs where we have bought fancy Rolex watches and fur coats. There was an egregious reason as to why we were doing that, but I've got plenty of stories to tell for sure. You can own one vehicle without having any issues. It's important to understand that a vehicle would include a boat. A vehicle would include anything that you would get registered down at the DMV. And so, I have clients sometimes who are like, oh, well, I want a motorcycle, but I also want the car. I'm like, great, you can only have one. Otherwise, the other vehicle is going to be a problem for you. You can have a prepaid burial. Some life insurance contracts are fine. Whole life policies are the ones that we start getting into trouble with. And that's because they accumulate a cash value. And so if the cash value of that life insurance policy exceeds $2,000 because you have the ability to withdraw that $2,000, it's a problem. And then we do have ABLE accounts, which we're going to talk about in a little bit. It is important to note that an outright inheritance will cause a problem if it is not in a special needs trust. And that's just because it is an income once it comes in, and then it's an asset every month thereafter. That said, if the inheritance is coming from mom or dad, there's also a possibility that we're moving on to a different income stream and not going to stay on SSI anyways. And that's because of this. All right, so these are the non-means tested Social Security benefits. So you have your regular retirement benefits. You can start to collect them at age 62, and the last day that you have to just like delay them is age 70. There are reasons why some people delay, and that's because for every month you delay after your full retirement age, they do give you credit for not taking it. SSDI would be if I got hurt, I am now disabled. As a result, I would collect under my own work record under the SSDI program. What most people don't realize is there are dependent benefits available under the Social Security Administration. This is often referred to as SSDI because it's a disability benefit. And basically, this would then be for a spouse or a child whenever you retire or become disabled yourself. As long as your child is considered disabled by the Social Security Administration prior to age 22, then what would happen is that child actually gets half of the parent benefit. This doesn't reduce down the parent's benefit, but they can collect 50% of the parent's benefit. And then at the death of the parent, they actually get to collect 34 or three quarters or 75%. The important thing is, and why do I work with families at age 18 to make sure they turn on SSI, is because we need that disability determination prior to age 22. It is very, very hard to retroactive at age 30 and say, oh, no, they were disabled at age 22. See, they've had this diagnosis, they were in special education. Social Security does not like to retroactive benefits. So getting that latched in becomes super imperative to the long-term support of your child. All right, so I'm just going to give you some hypotheticals. So if John is receiving SSI of $994 per month, John's father, Joe, retires, and he's now receiving, and Joe's dad's receiving $1,400. Well, John's going to be eligible to receive $700 per month from the Social Security Administration. They would take that $700, subtract out the $20 worth of from the unearned income of Social Security, and then they would subtract basically $680 from that $994. As a result, John will continue to receive SSI of $314, plus he will receive that Social Security dependent benefit of $700. So basically, he's going to have $20 more than the $994 he would otherwise be eligible. That's the max that you're going to be able to collect with SSI intact. All right, then we have our Medicaid programs. Okay, so historically, there have been two programs. You have had your CHIPS program, which is an income-based program for children and their parents. And then we had what we would call the age blind disabled Medicaid program. In here, you have to be aged, so that's 65 or older. There is a presumption under our law that once you hit age 65, we are all disabled. Legally blind or considered to be disabled under either the Social Security Administration program or through some sort of like what we would call a UAI screening analysis. Underneath the ABD category is where these waiver programs are. As I mentioned, these waivers, which are now, we have two major ones. We have either the CCC Plus waiver, which is for my individuals who do need nursing home level of care. This is not necessarily a benefit that's exclusive for my children with disabilities. This is the same one that I use whenever I am getting in-home care benefits for my elderly seniors as well, because now they've fallen and broken a hip and they can't walk again or whatever. The other like holy grail of waiver programs is the My Life, My Community waiver program. The waiting list on this thing is very long, and I'm going to show you why here in a minute. But that is where whenever you see, the CCC Plus waiver caps out at 56 hours a week. Sometimes you can get additional, but it's a temporary patch. Whereas the My Life, My Community waivers are really designed to kind of come up around your child and support them. It is important that you get on the waiver waiting list as soon as possible. And what they're going to look at is, does your child need assistance with things for reasons aside for some sort of developmental disability, and it cannot be exclusively for mental illness. So there is an exclusion under the waiver programs for mental illness. So I always tell people whenever we're walking through waiver eligibility, you need to make sure that you're focusing on the other things, such as an autism diagnosis or Down syndrome or whatever those other diagnoses are. When you start going into schizophrenia, bipolar, those types of things, the waiver's not designed for that. So that's immediately going to shut down some of the conversation. It's important to note that as long as you're receiving $1 worth of SSI, you are automatically enrolled in traditional Medicaid coverage as a disabled individual. Similar to the SSI, these programs the age blind disabled programs do have an asset limit of $2,000. All right, so why does it take so long for the waiver to get into place? These numbers are a little bit outdated, and I'm waiting for some statistics based off of the expanded Medicaid that we now have. We've had it for a while. But basically when you look at this, the navy blue are that ABD category. And so when you look at the smallest number of enrollees, it is that disabled population. However, when you go into the number of Medicaid dollars being spent, it's actually that smallest population eating up the over 50% of the Medicaid dollars. And so one of the reasons why is that these Medicaid waivers are super expensive. They're providing one-on-one care inside the home. It's not just like I've got to go to the doctor's appointments. Oftentimes too, with disability comes a lot more fragile symptoms, right? And so you might be hospitalized more often. You might be more susceptible to colds, whatever that might be. And so this is why though the waivers it's such a long waiting game. And it's just because they're expensive to the program. And so I think this chart just does a really good job of explaining, some of that. All right, we do now have what we call Medicaid expansion. So this came out with the Affordable Care Act. Surprisingly, Virginia was not the last to adopt it. We adopted it pretty early. But basically, prior to the Affordable Care Act, there was a gap in coverage for individuals between ages 18 and 65 if they did not have a disability or if they weren't blind. So what this now does is it just provides Medicaid coverage for individuals with low income. And so that is actually set at 138% of the federal poverty level. As you can imagine, those numbers change annually. So I look them up every time because I used to memorize them, and then there's only so much I can fit in my brain. So I figured that was not something that I needed to keep in there every year. Whenever I can easily look it up. Prior to expansion, if you had no income, that meant you didn't have any coverage. Now, if you don't have any income, great, we can have traditional health insurance coverage. It does cover the gap for working families who are not Medicaid eligible, but also can't qualify for marketplace subsidies, because we do have under the Affordable Care Act Medicaid marketplace subsidies. Well, we did. Right now, they're hot in the political arena. I'm not going to get into that. All right, so what is the Affordable Care Act? Basically, it was a law that prohibited exclusion from people from insurance policies because of pre-existing conditions. And they can't exclude out those pre-existing conditions anymore. So that is a positive that kind of came out of that. And with that came the tax credit. So a lot of this whole government shutdown is related to directly impacted to the tax credits, because that is how a lot of people on these policies are able to afford their coverage. There are 4 levels enrollment, and it's important to note that open enrollment runs from November to February of every year. There is a special enrollment period if you were to lose other health insurance. So for instance, if your child no longer qualifies under your work plan, which is a whole nother thing that happened with ACA, because they now have to include adult dependent children. But if they were to lose other coverage, they could enroll in the Affordable Care Act later. All right, some other benefits. We do have Section 8. We do have food stamps here in Virginia. And these are really just designed to help support individuals. There are certain residential programs that will take Section 8 in addition to the Medicaid waiver to be able to provide around-the-clock support for an individual and try and create as independent a life as what is possible for that child. So we do have various options that utilize the Section 8 and Medicaid for care. All right, so what do we run into whenever we're a family member and we're trying to plan for disability? So these are kind of some common scenarios, right? Number one, child support. Child support for an individual with a disability pursuant to court order can extend beyond the age of 18. Basically, our law indicates that it is parental duty to provide lifelong support to those individuals. And it could also be a gift to minor account. So I do run into this quite a bit, where parents may have put money into an UTMA account for their child. They were the custodian. They believed it was still theirs. If you have used an UTMA or a custodial account, it's important to note that that is the minor's money. And so we've got to do something with it if we're looking at public benefits. 529 education accounts. Once again, these are not exempted as an asset, and so these become problematic whenever we're trying to do planning. When you do have a plan in place, unstructured beneficiary designation. So I've seen plenty of clients who have done some sort of estate planning, but the beneficiary designations on, let's say, their 401k or 403b does not mirror their estate plan, right? So we might set up a beautiful special needs trust for the benefit of that beneficiary. And what happens is that they don't name the trust itself as the beneficiary, but they name the individual. Now it's their money, not the trust money. And so we run into some problems. There was a long history of, well, we'll just disinherit that individual. It'll make my planning much easier. The problem with that is you're relying on another child to, make sure that their sibling is taken care of, or better yet, that their spouse will let them use their inherited money to provide support for their sibling with a disability, right? And then that child passes. If they haven't planned for their sibling in their estate plan, well, now it's going to pass into their estate, and now these other individuals may or may not provide the support. So I am a very firm believer that the best thing that we can do is get the assets and the money to where you actually want it. If I hear a family tell me, well, I'm just going to leave it all to the brother, they know that what they're supposed to do, I actually will refuse to represent that client, because it goes against everything that I stand for. Not using a proper trust. So there are times where trusts are drafted improperly. I am known at a national level for the special needs trust work that I do. And so when that happens, we can use a process that's called decanting. And basically, we take an impure trust or an improper trust and we can decant it into a trust that would be exempt for public benefits. And then, of course, no planning at all, right? I think it's easy for us as parents to just ignore the fact that we need to get this done. We don't necessarily like to talk about death and disability, although it's something I get to do every day. But I'll tell you, whenever I had the twins, there was a time where my husband and I were flying down to Key West. I was on the plane. I'm like, oh my God, I didn't make those changes to my trust. You know, this is something that I live, eat, and breathe. I can do my amendments myself, but it was just getting around to getting it done. It wasn't a priority for me at the time, but as soon as I landed, I made sure I got my trust amendments done because I still had to fly back home. But my husband and I are both on the plane, so that's where the risk was. All right, so what should you consider, you know, as a parent? First and foremost, having a really good power of attorney. I often say that this is one of the most important things for all of my clients because you're still alive. You know, what am I looking at whenever I see other power of attorneys coming to my office? So number one, terms matter. We are what's called a Uniform Power of Attorney Act state. And what that means is that we're governed under a uniform law and we've adopted what we believe is, you know, good and tries to simplify things across state lines. But basically what I'm looking at is, does the power of attorney allow a parent to support dependent children? Because without that, I'm not allowed to use your money for the benefit of your child. Can we make gifts? And do they have to be outright or can they be in trust? Does the power of attorney allow us to create a trust for the benefit of your child? So these are all important things, but basically under the Uniform Power of Attorney Act, there is a provision that says that there are some things that are so personal in nature to us that unless I specifically put in your power of attorney, you can't do it. So if you're going on LegalZoom, Wills and Trust, for goodness sakes, there's these financial advisor seminars that are popping up that they're just life and health agents. They're not actual financial advisors. And they're talking about planning, right? And I've seen these documents. They're not great. Especially in my special needs arena, I need to be able to make sure that we've got lots of power to be able to provide the support that you have been. You know, wills and trusts, we need to make sure that we're not providing outright gifts to an individual who is on public benefits. We need it to go directly to a special needs trust. And then whenever we start talking about allocations, right, does the individual with special needs need more support than the other kids? You know, it's not necessarily everybody gets equal shares. You know, a lot of times when we talk about living situations, mom and dad will say, well, you know, I need, you know, child A to remain inside the home because this is their home. They can't go buy another home. And so as a result, you know, a lot of times that house will go to the special needs trust. If the other kids want to move in and help provide care, great, then they can come live inside the home, but the home will follow the individual and there's not going to be any incentive to sell the home because the other kids are not going to get a benefit if they do, right? They're not getting the extra cash in their pockets. Same thing with retirement benefits. There are some cases where leaving more IRA 401k money to an individual with disability is actually more beneficial because there was what was called the Secure Act that was passed a few years ago. It's actually quite a bit of time now, but basically what that said is that unless you've got fit an exemption, you've got to pull out that money over 10 years. It's all taxable as it's coming out. One of the exemptions is a disabled child. And so if you're an individual with a disability, you get a lifetime stretch. And so that can help reduce down tax implications for everybody. All right, and then we get to the actual individual themselves. You know, their powers of attorney and advance directive or guardianship and conservatorship. What trust are we going to use? We've got military SBP that helps provide support. Child support is the child's benefit, so we're going to talk about that. And then how do we fund these things and what housing options are available? All right, so first and foremost is the surrogate decision making. And it's important that we start talking about this prior to age 18. I can actually file a guardianship and conservatorship in the court at 17 and a half. I get a lot of parents who try to come in like a week before the 18th birthday. I can't snap my fingers and get it done. It's actually impossible for me to get a guardianship done in a week. By statute, I have to give at least 10 days notice to certain people under the code. And so making sure that we can pre-plan this and kind of get it done, you know, before age 18 is important for, you know, so we don't have a gap in the ability to make decisions. Fundamentally, we do not get to choose which option we get or we go through. So I have this all the time where parents are like, but I don't want that. And I'm like, okay, well, Does your child understand the nature and effect of a power of attorney? No, they don't. The law is very clear on this. You either have capacity or you do not have capacity, right? Yeah, we do get areas of gray where, you know, I'll get a doctor's note to determine, and the doctor will basically opine, yes, they understand, no, they don't, because I'm not a medical professional. But if you do not have capacity, we have to go the guardianship conservatorship route. There was a supported decision-making statute that went out, but when you actually read the statute, and I actually wrote an article for the Virginia State Bar about this, but basically it allows you to assist somebody in making a decision. So like you can be on a team with them, but you do not get to make the decision. They still have to make their own decision. So if you disagree with their decision, too bad, so sad, you have no legal authority to act on their behalf. All right, so power of attorney advance directive, you have capacity. And basically it's a document that's going to say, hey, I have appointed this individual to help make decisions or to make decisions on my behalf. Under there's no accountings. There's, you know, there could be if somebody ever questioned what you were doing, but big picture, they're not mandatory every year. There's no bonding requirements, and you're still going to need a representative payee potentially. We'll talk about that in 1 second. On the guardianship route, the judge is going to determine that this is an incapacitated individual, and the court gets to decide who it's going to be, what powers there's going to be, and if there's a blended family situation or like step parents and stuff involved, it could get a little bit messy sometimes in the guardianship arena. Under the conservatorship, there is an annual accounting requirement. There's also a reporting requirement for the guardianship. So every year you've got to report to you know, about what is going on within that, within the guardianship. There's a surety bond on the conservatorship, and what that is, that's an insurance policy. It basically says that you're not going to mismanage your child's affairs. And if you do, the insurance company will put the money back into the estate, and then they will come after you for liability. All right, this representative payee. So if you go back to 5th grade, it might be 4th grade, somewhere around there. Those are my kids' ages. But basically separation of federal and state government, anything not expressly reserved for the federal government is a responsibility of the state. So if you've ever read any federal law, there is no mention of a power of attorney in there. All right, so both power of attorney and guardianship, they are state creatures governed by state law. However, Social Security is a federal program. And so they have said, congratulations, we do not have to respect the court appointment of a guardian. We do not have to respect a power of attorney. And instead, they go through what's called a representative payee process, where they pick the person who will manage the Social Security benefits if the individual cannot do so themselves. So, you know, in the power of attorney context, we may not need a representative payee at all, but it's important to understand that, yes, there is a roadblock still there. We've talked about the capacity, and like I said, when I've got any doubt, I have to obtain a physician's opinion. I do need to assess this outside of the presence of the family and the agent. I need the individual to let me know what they know. Now, granted, whenever I talk about this, I usually talk about it in very simple terms, you know, to make sure that they're understanding what's going on. But I can't have family members feeding information, because that's not telling me whether or not what that individual understands. You know, we do have a presumption of capacity, and you know, that's important to know, but basically the fundamentals are, do they understand the nature and effect of the document, or the nature and the consequences of the documents? Same thing like for parental stuff, these hot powers that I talked about, you know, the ability to create a trust, the ability to, you know, fund the trust. These are things that are important for the individual themselves as well. And it does create a fiduciary duty. So you have a legal obligation to manage in accordance with the terms of that power of attorney. And as I said, they're not just a form. You've got to understand what's in there. They do survive incapacity, and, you know, so that way, if somebody's in a car accident, the power of attorney will stay in effect. The advanced medical directive is 2 documents in one. Basically, it's your living will. So it's going to talk about what do you want in the event, in terms of extraordinary measures, in the event that you've got a terminal condition, or if you're in a coma. You know, this is probably the hardest part for my young kids. So usually when I'm working with special needs families, I say, you have got to talk about this with your kid before you walk into my office, because now you've got the attorney who they do not know talking about, well, do you want the plug pulled if you were in a coma? You know, and it's kind of hard to talk about, especially if they've not gone through it. And so that's an important conversation for families to have before they get in with me to sign documents or to talk about them. And then it also talks about the medical power of attorney. So who is it that's going to make medical decisions for you when you cannot? It is important to note that an advance directive in Virginia is only effective when 2 physicians opine that you are incapable of making your own decisions. So if you have a child signing this document, chances are it will not give you the authority to make their medical decisions for them because they still have capacity and they can still make those decisions if they have the capacity to sign this document. We do include HIPAA waivers, and so that way you can still talk to doctors. We do a separate document. We build it into the advance directive as well, but we do a separate document merely so that way you have some transparency, but once again, you don't actually get to make the decision until they cannot make their own. All right, guardianship and conservatorship. Guardianship is of the person. This is who's going to be making the residential and medical decisions. And then you've got the conservator of the estate. This is all financial decisions. I mentioned some of these duties earlier, so I'm not going to go through it just for time's sake. Then we get to meats and potatoes. This is the trust. Okay, so when I've got an individual with a disability, or even some kids that do not have disabilities, but maybe they are not financially responsible, right? We want some sort of trust to kind of protect them. There are special types of trust called special needs trust, and they are drafted in a way to make sure that they are not countable for public benefits eligibility. Some of the key phrases are that it is designed to supplement and not supplant public benefits. So what does that mean? For my kids that are in wheelchairs, right? Medicaid will only cover a wheelchair every few years. If something happens to that wheelchair in the meantime, and Medicaid denies a new wheelchair, well, we could use the trust to pay for it. But we would have to go through making sure that there's a Medicaid denial first, right? And there is some durable medical equipment that they don't cover. And so those are easy cases, but it's just important to know that it's the whole purpose of this thing is so that we can continue to get public benefits. So the trust will supplement and not supplant those benefits. All right, so these are the types of special needs trusts that actually exist. Everybody just thinks that there's one. There is third party and self-settled. So when you're doing your planning to make sure that when you pass, things are taken care of, we would use that third party. Third party means whose assets have gone into it. Self-settled is the individual's own assets. Okay, so this is where whenever I have a child that might have gotten into an automobile accident and they're on Medicaid or SSI, those are the types of trusts I would use because it's their asset that they've received. You'll see here that the third-party special needs trust can be inter vivos, meaning it's effective during your lifetime, or it can be testamentary, meaning that it's only effective at your death. Those are just standalone documents. And then you have what's called a pooled special needs trust, which is managed by a nonprofit organization. We are very blessed here in Virginia because we do have Commonwealth Community Trust out of Richmond. They are probably one of the best in the country. They're my favorite. They charge less than any other pooled trust that I have been able to find. And their attorneys and staff go to the same special needs conferences that I go to, which means that they know what they're doing. So I work with them quite a bit. Then in the special needs trust arena, you have what's called a D4A trust, which is your standalone trust. It's not governed by a nonprofit. And then you do have your pooled trust, which is governed by a nonprofit. All right, so this is a very, very important chart. I'm not going to go through each one of them. However, what you'll see is who can establish it. A first-party special needs trust can only be established by the individual themselves, a parent, grandparent, legal guardian, or court. The third-party trust can be created by anybody, right? I just want to leave money to this person that I love, but they've got a disability. I've already said about the funding. Is it their money or are they receiving it from somebody else? And then the first party has to be a person with a disability. For a third party, they don't necessarily have to have a diagnosed disability, but maybe, we know that there are some limitations. And so we want to, still use this because we believe maybe they'll be entitled to benefits later. I'm not going to go through the grantor trust stuff, but the most important thing for my families here is that the first party special needs trust, I call it the you can't have your cake and eat it too rule. There's a required Medicaid payback. So under federal law, when they enacted this, basically what they said is that that's fine. You can save money in here. I work on these things and $12 million goes into them, right? You can use it and you can use every last dollar during your lifetime, but at death, whatever remains in there is subject to a Medicaid payback. So if there's $100,000 left in the trust and there's a Medicaid lien, or Medicaid has spent $1 million on this kid's lifetime, during this kid's lifetime, then what'll happen is that they will take the entire $100,000 as, you know, to help pay back the program. If there is $1 million in the trust and only $100,000 lien, then at that point in time, they will take the $100,000, you know, take $100,000 of the million, then $900,000 would go to the rest of the family. So a lot of people don't like that. We want to avoid it to the greatest extent possible, but that is probably the biggest difference for my families in understanding the two. Once again, we don't get to pick which one we choose. And if you do not create that third-party special needs trust and you leave an outright inheritance to somebody who's on public benefits, it will have to go into the first-party special needs trust because it has vested down to them upon your death. So it's just important to understand the differences there. All right, so funding options, what are we normally looking at and how do these things play out? You know, it can be life insurance. This is where a lot of my families, especially young families, you know, look at funding. I mean, that's how I'm going to support my kids if something were to happen to me today. You know, we can put a house in there. It can be cash or investments. The other important note is child support. So once again, child support is the benefit of the child. And so what that means is that it needs to go into a first-party special needs trust if we're on public benefits. Otherwise, it is considered income to the child and SSI will be reduced. It'll also look at like income for Medicaid, and there are under the waiver programs, there are income caps there. And so we don't want to max out income and then lose benefits. If we've got a long waiver waiting list, you can imagine something like this. They throw the kid off with benefits. Now they don't have their waiver and they got to go back on the waiting list. So that's problematic. It can be retirement plans. It is important to talk about the tax implications with this. And so any attorney that you're working with should have a very deep knowledge of tax. I teach tax at Stetson School of Law. So, you know, I try to keep up with it as much as possible. I'm a little bit of a nerd there. And then you have what's called the survivor benefit plan. And the survivor benefit plan is basically the military pension. And there is upon retirement, you can make an election for an adult disabled child. You pay, it's about $20 a month, the cost of it. And basically you can assign that payment then to a first party special needs trust. Once again, child's benefit. So the federal law, when this came down, it was about 10 years ago, this changed. But they have essentially said that it needs to go to a first party special needs trust. So I don't get to pick which one it goes to, but that is a huge benefit because, you know, some of my kids can receive $3,000 under SBP, plus they're receiving their Social Security. If you combine those two together, well, even just $3,000 a month would kick over the waiver limit. And so then they would lose the care, you know, benefits. So all of this is a big giant puzzle that we've got to talk through for sure. All right, I've already talked about this. The child support, the important thing is it has to be court ordered. So we cannot agree to pay it to a special needs trust by like stipulation agreement. It must be in a court order. Otherwise, Social Security Administration will basically ignore that assignment to the trust. All this PLR language, it's more from my reference than anything else, but those are private letter rulings. And so there are times where I've got individuals who have worked, they've got some sort of, you know, 401k or IRA, or they've inherited one. And this basically talks about, you know, the planning of it. So if it's a Roth IRA, I don't have to worry about it. But if it's a 401k and it's the individual's own, it's interesting because the IRS essentially said, no, you can't move your own IRA into a first party special needs trust. They didn't get into the grantor trust provisions and kind of everything else there, but they basically said, no, we're not going to allow it. But we do have three very express PLRs on point that say, if you have inherited an IRA, we are going to allow you to roll it into a special needs trust because it is a grantor trust. Practitioners, we've got no clue why the IRS has not treated them the same, because it's the same concept whenever they did this. But, you know, I can't fix the IRS. Why is this important? Tax money that goes into a 403b, 401k, traditional IRA, 457s, they've not been taxed yet. So as it's coming out, it's taxable. So if I get a kid that has received $100,000 from parents as 401k, rolls it into an inherited IRA, they now have $100,000 of assets. If I had to liquidate that to move it into the special needs trust, that child is going to take they're going to recognize $100,000 worth of taxable income at that point in time. As you can imagine, we're going to be paying an unnecessary tax liability as a result of that, phantom increase. So that's a huge, it's hugely important. But once again, it would go into a first party trust, not a third party trust if we had to do that. I'm not going to get into qualified accounts. Able accounts are our next big tool, and probably the final thing I'm going to be able to get through tonight. These for me, have very limited purposes, and and it says currently $15,000. It's actually $20,000 this year. In order to fund these things, you used to have to be 26. They have increased the age now to 46. And you have to be either on SSI or SSDI or file a disability certification. And these are basically savings accounts for individuals with disabilities. There are some limitations to them. So whenever these things were first coming down, it was, this is the answer to special needs trust. You're never going to need an attorney again. If an ABLE account exceeds $100,000, then they're going to suspend SSI benefits, and you can't put more than $300,000 in there. Also, if I can't put more than $20,000 in at a given point in time, what's going to happen is that they receive an inheritance of $100,000. I can't get it all in there. So it's a very small thing that I use. And under federal law, there is a Medicaid payback. Virginia has waived it for Virginia residents. And some, like the Pennsylvania ABLE accounts, they actually waive it for anybody in their program. That's what they're used for. I've already talked about that. All right, so just kind of putting this all together for you guys, because I know I've talked about a lot of tools. If Sally's working part-time and making $300 a month, and she was on SSI, they're going to ignore $65. And then basically it's a 50-cent reduction for every dollar she earns. So there is going to be a $117.50 reduction. So she's still going to collect $875.50 from her SSI. If Sally lives at home with her mom who doesn't charge her rent, we're going to get that 1/3 reduction. And so it's going to be reduced by $331. So now we've only got $545.17. If Sally receives SBP now because of her dad's death, and he was a veteran, now it's $600 reduction. It's they ignore the first $20 because now it's unearned. And then it's, dollar for dollar reduction. So basically, Sally's not going to get any SSI under that scenario. And by the way, in order to automatically be enrolled in SSI, she's got to be receiving at least $1.
Hey, Shannon.
Yep.
We have a question from one of our attendees, and I'll make it a little bit more generic. But if a family has previously opened a 529 plan, would you recommend that they continue contributing to it or stop?
A 529A or so an ABLE account is a 529A account, but if it's an educational account, then it is going to be a problem. There is a rollover provision under ABLE that allows us to roll over money from a 529 into an ABLE account. They're not my favorite tool because of the limitations. There's a lot of financial advisors who tried to push them as a tool, but they're expensive because you can't really put a whole bunch of money in there, but then there's like costs associated with maintaining them. I use them for very small windfalls, so very small unplanned inheritances. I use them whenever an individual works and needs to save, wants to put some money in there and just save it up and have access. It does allow for some freedom for the individual. Other than that, I use it for in-kind support and maintenance reduction. So if based on calculations, let's say the child owes mom and dad rent of $1,000 per month, and they're only getting $994 a month in SSI, well, they can't pay for it, right? There is an exception under the Social Security rules that essentially say that payment from an ABLE account to pay rent it's not coming from another source because that account is in the kid's name. So I can't use a special needs trust and pay directly. That's coming from somebody else. But I can use an ABLE account to subsidize that shortfall. And then what happens there is, they get to continue to collect their full SSI check. So very limited things. I would say that it's probably a much more in-depth discussion, but they are not my favorite tools. I much more prefer third-party SNTs because there's a lot more flexibility in there. So sorry, long answer. All right. So Sally lives at home with her mom who charges her rent. Great. There's no reduction, right? Because we're paying our full share. Mom can then funnel that money into that third-party special needs trust and basically, just save it for her daughter because she didn't want to charge her rent to begin with. If income's not sufficient, that's where the ABLE account came in that I was just talking about. Congratulations, and I didn't update the slide. Benefits now still $9.94 per month. All right, if the self-said special needs trust receives that SBP payment of $600 per month, once again, no reduction, so $9.94 per month. And then if Sally's working part-time, she's making that $300 a month. That's the only reduction we're getting. So on top of being able to collect her $600 per month, on top of being able to, save money in the third-party trust because we didn't want to charge rent, she's still collecting $873.50. So that's how we put kind of all these tools together to make it work for an individual. All right, so I know we're running short on time. If you guys want to take some questions, I am in no rush, but I know everybody is, it's getting late.
Shannon, while we're waiting on that, I can go ahead and share my screen for the next slide while we're giving parents a chance to ask any last minute questions. Let's see here. All right. Again, parents, we'll give you a few more minutes to, while I close out, to ask any more questions. But in the meantime, I want to thank Shannon for sharing her expertise on future financial planning for students with disabilities. Your knowledge and practical guidance provided valuable insight that can help families feel more confident as they plan for their child's future. So we greatly appreciate that. Displayed on the screen is a list of Chesapeake Public Schools transition specialists by school. If you have any questions, please reach out to your child's transition specialist, or you can contact the Office of Exceptional Learning at 757-547-0153, and they could provide you with the contact information for your transition specialist. I don't see any more questions in the chat. Again, I just want to thank the panelists, Shannon, for your wealth of information. Should you have any questions about future webinar or need additional information and or resources, you can contact our office at FACE, F-A-C-E, at cpschools.com. Keep in mind that Let's Talk is the perfect two-way communication for any comments, questions, suggestions, or concerns that you may have. Also, you can stay connected to Chesapeake Public Schools through the different platforms listed on the screen. Make sure you scan the QR code to download our app to receive notifications about important events. Again, I would like to thank Shannon for sharing her information with us. And please remember that this webinar has been recorded and will be uploaded to Chesapeake Public Schools YouTube page in the next few weeks. Thank you again for joining us. And it looks like I may have
Yep, we do have one question.
Yes.
Yes. So Shannon, we did have a parent who asked if you could give an approximate cost of setting up a special needs trust and guardianship.
So there's a lot that goes into that because it also depends on, are we doing other trusts for other kids? You know what I mean? Like there's a much more complicated process. I would probably estimate average cost of guardianship right now is going to cost $6,000. That there are other attorneys who are charging $8,000 to $10,000 that I am aware of right now. Anytime we go through the court, it's a difficult process. And on top of it, our General Assembly is continuing to add more and more and more onto what we need to do to even get these things through the door. So they're not helping us at all. And then the estate planning, usually for a married couple, if it's relatively simple, you're probably looking in the ballpark of about $5,000 there. And that would get you like a full plan, power of attorney, advance directives, wills, and then the trust.
All right, great. There's one more question. Oh, actually, she said
It
thank you
said
for the
thank
information.
you. Yeah.
Yes.
Oh, absolutely.
Right.
It's always, some people shy away from talking about the fees. I don't really, I mean, you have to prepare for it. And, I've got families who, unfortunately, like they're retiring at the same time their kid's turning 18. You know what I mean? And that cost, that could be a $20,000 matter between just basic estate planning, guardianship, plus the first party S&T for, that military SBP. And so it's one of those things where it's just like, hey, being able to like chunk and chew it and prepare for it, as opposed to me looking at you and being like, hey, by the way, this is what it costs. I think it's beneficial for families.
Awesome. All right. Again, thank you, Shannon. Please remember that this webinar has been recorded and will be uploaded to the Chesapeake Public Schools YouTube page. Thank you, families, for joining us tonight. And remember that families and communities work better together. Thank you and have a great night.